Welcome back to Good Law, Bad Law. On today's issue, we're going to be talking about something that probably a lot of us take for granted and maybe don't even really think about all that much, but we should. And it's the issue of consent. And to help us work through the contours of consent and the many, many different areas of life where consent is really so important, is my guest today, Nancy Kim. She's a professor of law at California Western School of Law in San Diego, and she's the author of the new book, Consentability, Consent and Its Limits. So, Nancy, thank you very much for being on the program.
Oh, it's my pleasure to be here. Thank you for having me.
I read the book over the weekend and this week, and boy, there's a lot of ways that consent that I didn't realize that consent plays such an important role. And one of the big issues that so many people are talking about is, of course, is the issue of consent in sexual relationships, and we will talk about that. But I want to spend some time looking at other aspects of life where consent comes into play. But before we do any of that, give us a little background on yourself, Nancy. Your professional background and what you teach at law school, and how you came to this issue of consent and to devote yourself to it in this new book of yours.
Sure. I am a professor of law at California Western San Diego, as you mentioned, and my primary research areas are in the contracts and technology and the way technology shapes and is shaped by the law. And so the issue of consent has always interested me because, first of all, just because it touches on so many different areas of law. Um, because we live in a free society, we sort of assume that um, anything goes as long as, like, the general principle is, pretty much anything goes as long as you don't hurt other people, as provided you provide consent, right? So that underlies a lot of our law. And I was doing research on another book on online contracts. Um, and what interested me was the way consent was constructed, how
Mm-hmm.
we say that if you do certain things, like if you click on an icon, or sometimes you don't even have to click, you just have to be on a website with a link on it. Um, the law, courts started to sort of interpret that, see that as you consenting to the terms, even though you never clicked on the link or actually read the terms, you never accessed the page. And so it got me thinking again about how consent in the area of contracts is different from consent to sexual relations or consent to certain in certain activities in tort law. And so what is it that we mean when we use the word consent? And so then I started down this path, and
Right.
it became this years-long project.
Well, and what we're going to, I want to also talk about the idea of consent in some new technology context, because I think the issue of consent is very challenging, as you discuss in the book, in some of those areas, and also some areas of life where you have to ask, is this even something we can consent to, such as dangerous activities, or is this something the government or the state should have a role in regulating? And of course, the government does in all sorts of ways regulate things that we can and cannot consent to. So we're going to
Right,
touch on,
and actually,
yeah,
that's a good point. I started to talk about how I got into this research area, and in looking at how technology shapes the law or is shaped by the law, what what you see a lot of is the way that, well, if there's a new technology and we're not really sure whether or not it's permissible, whether or not it's um, lawful, a
hmm,
lot of times the way companies got around that question of, lawfulness was by getting consent from the consumer or from, the subject. And so if you have consent, then you don't have to worry. There may not be a law that says you can't do it, but there's no law that says you can do it. So you're not really sure whether you can do it. Like, for example, data collection, right? And so what you do is, well, if somebody consents to it, then you diminish your risk of doing something unlawful.
Well, right,
And
but I mean,
so you start
clearly,
to
I mean,
see,
you don't have to think too hard to come up with some examples of things that can, even if you consent to it, that doesn't cure the unlawfulness of the act. I mean, except in some small parts of the country, prostitution is illegal, and it doesn't matter that that both parties consented to it. I mean, the government, state,
right,
all
right.
said,
So that's the other part of consent, right? Or that's actually the issue of consentability.
ah,
So
which is the
what
title of
interested
your
me
book.
were yes. So there are two things here. First is what is consent, and what was interesting to me in the context of new technologies was what constituted consent. How consent was constructed, what was viewed as consent,
Right.
and then the issue of consentability, which is even if it were possible to get valid consent, are there some things to which we should not allow consent? And if so, what are they, and why should we disallow those activities?
All right, well, we'll get into some of these specific examples, but I know that what you set out to do in this book, beyond just exploring some very interesting, case studies and examples where consent is an issue, was to try to come up with a framework for consentability. What is consent, and how do we know there's consent, and what are some things that can happen to destroy consent or change consent? So maybe you could start by laying that out for us, and what is consentability anyway?
Sure. Okay. So I use the term consentability in two different ways. The first is it possible to consent to something? So consentability in the sense of possibility. Is one capable of consenting to something in a particular type of activity? And the second meaning of consentability is legality. Is it legal to consent to something? And by the first, the issue of consentability in the first sense, whether it's possible, really has to do with the individual's understanding of what is happening. Like, can you really consent to an activity that you have never experienced before, and you don't understand? Nobody else has experienced it. For example, I use the example of cryonics, right, which is
Hmm.
a very extreme example. Can you
Well, tell that
can you
story, because
actually
that's a good illustration right there. That's
okay, um, so do you want to tell me the actual
yeah, just
incident that I
briefly.
referred
Yeah,
to in the
just
book?
briefly, because
Okay,
that helps.
so there was a young woman who was diagnosed with brain cancer, and she was 21 years old in Rosie, and when you're 21 years old, this is you want to find a way to save your life. So she turned to cryonics, and the question so the question was, or the question I posed in the book is, when you're 21 years old and you learn that you have are going to be, that you've been diagnosed with a brain cancer and you don't have much time to live, are you capable of consenting to something that requires, you know, that's completely unknown? It required, so she would essentially, if it works out, which it's I personally don't think it's likely, but she would wake up sometime in the future, and it would be sort of in a disembodied state, and probably sort of uploaded to a computer, and really not have any control physically over her physical self or her environment,
Yeah.
and she wouldn't really know what the world would be like in the future. And so the question is, in that type of situation, can you say that one has validly consented? There's so many unknowns, and the person who is making the decision is in such a vulnerable state. They don't, are they actually making a choice?
Right. So the conditions for actual consent then are, it has to be something that you actually can consent to, and there might be a number of factors that go into that. Some if you're dying of brain cancer, you might not be in your right mind, for example. So
And
that
you're young. And you're young. You're
and you're
21 years
right.
old.
A minor, we know from the law, there are many things that a minor cannot legally consent to because it's felt that they don't have the legal capacity to consent in the same way that an adult does. And maybe we can question the legal capacity of lots of adults we know too, but at least in the law, we say minors, don't have that legal capacity. And then secondly, it has to be something that's lawful. Is that
Right.
okay?
Well,
So
I mean, that's generally how, in most, as you know, there are different sort of the contours of that of consent are different in sort of different areas of the law, tort or criminal law or contracts. But yeah, that's basically true as far as what you need. And so in the book, I really try to flesh out when it's funny when we say consent, we often say, well, the consent wasn't valid, and it sort of doesn't make it doesn't seem to make sense to speak of consent in terms of validity because you think, well, if the consent wasn't valid, it wasn't really consent.
mm,
So there's something else going on there when we use the word consent, and really when we use the word consent in a legal sense, we're really talking about a conclusion that's reached based on certain factors, like in contract law, on a manifestation, right? Or
right.
on certain words or deeds or acts that were done, and we conclude, okay, therefore there was consent, regardless of the subjective state of the individual.
Well, you brought up contract earlier, and now again, and as a civil lawyer, I'm often looking at a fact pattern for a case and seeing that there might be some elements of contract and some elements of tort law, which we say, um, and they're different. They are separate in many important ways.
Mm-hmm.
So how is consent different from contract?
Well, when you're talking about contract law, the law requires a manifestation of consent. So usually that's a signature on the page or a click on an accept icon, right? So manifestation of consent and like a I mean, that's pretty much it. I mean, it
Mm,
used to be, notice and manifestation of consent, but that's been collapsed. So basically, if you manifest consent, you have notice, right? Um, and that's a very low standard, and it doesn't sort of make sense when we deem that a consumer has consented to terms that, a lot of times they say, I don't remember clicking on that because we have this automated response now online. We just click, click, click. We don't even think of it as a contractual undertaking, right? Um, and so, it's a very low bar, and I think that we should really reconsider,
yeah.
um, the one click fits all transactions. I mean, and that's what I put forth in my book. I think it really should depend on what it is that we're consenting to. The level, sort of the robustness, right, of consent should depend on what it is that we are agreeing to, and that is a part of my consentability framework, which
But
is
see,
that
I always thought contract was, an agreement, and yeah, it could be written, but it could also be verbal, where the parties are reach an agreement and an understanding. We learn in
right.
law school of an offer and an acceptance of the offer to do something or perform something or buy something or sell something
Hmm.
for something, and that's the consideration that in exchange for that agreement, you're sealing that deal, whatever it is, with the exchange of something, whether it's as
Right.
insignificant as a peppercorn, which is what my contract law teacher always used as the example. I don't know what you use in your course, but it doesn't have to be much, but it will seal the deal. Where consent, um, at least the
Like,
way the
where did
word
that come in,
sounds,
right?
yeah, well, the word almost sounds like permission, rather
Yes.
than some type of agreement.
Right, right. And so that's what's interesting is that in first year contracts, we say in order to have sort of a validly formed contract, you need mutual
Hmm.
assent, not consent, mutual. Well, sometimes people say
Right.
consent, but
Hmm.
mutual assent, offer acceptance, and consideration. But yet, when we talk about whether or not the contract was agreed to, we speak in terms of consent. And I think the consent kind of encompasses all of that, meaning that if you could have because it is relevant not just to determining whether or not you um, there was a formation, like you knew what you were agreeing to, that you weren't signing a piece of paper because you thought it was, a field trip permission slip for your daughter, and instead it was the deed to your house, right? But it also is relevant when we're talking about defenses, like ways to get out of a contract,
Mm-hmm.
right? So then we say, like unconscionability, duress, all those have to do with consent, right? The fact that you did not, in fact, it seems like you consented, but in fact you did not consent to enter into the contract. You were forced or you were tricked.
So they are similar then, because you can think of, and maybe we can talk about a very hot issue right now. And I know we won't spend the whole episode talking about it because there's so much more than this, but it is really something that people are talking about a lot, which is, the idea that, as we've evolved in understanding about, uh, sexual relations, that no means no, and there has to be consent, and and then there's kind
Mm-hmm.
of the reaction to that, and some people will even say, "What? I have to have a contract with somebody if I go out on a date," as if that's
Mm-hmm.
a bad thing, but it conjures up images of lawyers coming into the room before that first kiss and saying, "Sign here and sign there," and that's not really what it means, um,
No.
right?
And I
So,
don't even think that would help.
yeah.
Frankly, I don't think that would help. I mean, it's not. I mean, would we just get into this sort of mass contracting situation we have now, or I mean, that's it's there's another. It's not getting to the real issue, which is the issue of communicating desire or what it is that you want, and that's what where consent comes in. What you're doing when you consent is you're communicating
Hmm.
that you want something, whether it's enter into the transaction or you want to engage in sex, whatever it is. That's what consent is supposed to do. It gives you permission to do something which would otherwise be unlawful, because you want to do the thing, you want to engage in the transaction. And so the difficulty is, what does it like? Do you actually want to engage in the transaction, or do you feel like you have no choice? Are you being coerced? Are you
So
being tricked? Are you being
communication, I mean,
manipulated?
that's very interesting. So the communication of consent, just like in a different context, similar but different contract, where the contract, where as you say, signature on the line becomes very important to know whether in fact you had a contract, but also in this related context where we're talking about consent, the way it's communicated and understood by the other person or by the other party becomes very important.
Right. But there's another part of this which I think we um, that the law sort of incorporates, but never really explicit or often doesn't expressly sort of acknowledge or discuss. And I think it needs to be part of the conversation regarding consent. When we talk about consent, typically we're talking about the consenting party, right? And
Mm.
so the burden is on that party to show consent or non-consent. And that's really the issue right now, is that in the past it was you had to show in the sexual context, you had
Hmm.
to show you did not consent. And now it's you need to show that you consented.
Hmm.
Still, the burden seems to be on the consenting party. But I think there's another there's another party involved here, and that's I refer to the other party as the consent seeker, right?
Okay.
Um, and so the consent seeker, so much depends on what they do, right? Which is why I don't think signing a contract is really going to get us to where we want to go. So much of it depends on what the other party does or knows, like how they behave. And I think the assessment of whether or not there was valid consent should take both parties into uh, um, account. So I refer to that as we have the harm principle, and then I've referred to it as the opportunism corollary, which is that we should make sure that there is that valid consent, meaning that and valid consent is a manifestation or a communicative act with enough sort of knowledge, right, and volition on the part of the consenting party. But on the other hand, the other party shouldn't be doing something that he or she knows will harm the consenting party. They shouldn't sort of do something knowing that it's harmful to somebody else. I mean, why should we allow, as a society, somebody to harm somebody else just because the person gave consent, technically consented? And I think we have to look sort of at both parties, and I think we would resolve a lot of you know um, issues if we really thought about consent as a relational um, question, as opposed to just a yes or no. Like we need an answer. Did this person consent? It's not one sided. It's mutual and it's relational.
Yeah, that's very interesting, and the issue, the factor of how it's communicated and how it's understood also requires just that. It requires some communication. I mean, in the olden days, so you might reach over and kiss someone and say, "Well, I thought she wanted me to kiss her." There was no communication. There was just signals, maybe, or there was just assumptions. Now we're saying consent requires, as you say, a more relational approach, which has to involve communication to make sure the thing that you're seeking as the one seeking consent is also desired by the other person. It's
right.
Really comes down to, and there could be a lot of ways that communication could take place, but it's really saying I think we're still talking about a romantic or intimate relationship
I think we're talking about in all sorts of consenting scenarios.
Yeah.
I think that's got to be true. And what's interesting is the law recognizes that when we're talking about, for example, contracts, because those are the cases I've looked at the most. But if one party knowingly knows that the other party is mistaken about something, the law will allow the mistaken party to get out of the contract, right? So much of it depends on the opportunism or the sort of bad faith of the other party, of the consent seeker.
Well, right, but again, in a contract situation, it's in everybody's interest to write it down in a way or spell out the terms openly and completely so that there is no misunderstanding. Otherwise, you get into problems. Did I want to pay $2.50 for that bushel of widgets, or did I think it was going to be $2.60? But it does become more problematic in so many of the contexts that you're exploring in the book. I mean, maybe the most complex is in the context of a human relationship, two people, and what did one person understand and what did the other person understand, and you talk about also consent can deconstruct, that the thing that you thought you had consent for, there can be conditions that come up that change that. And now you're in a situation where you had consent, but now you no longer have consent. I mean, in a human relationship, that can be enormously complicated.
Right, right. Um, the way that I like to think of it is that one consent, like if you're talking about a sort of progressive activity, you consent to sort of a step in the activity. It doesn't mean you've consented to all the stages, if you know what I mean, right? So right. And I think that we sort of have to reach a point where we acknowledge, or we have to sort of set the parameters of what is considered reasonable, right? And I think right now that's what's shifting. What is reasonable? If you consent to kissing, that doesn't mean that you've consented to sex, right? And so the question is, how do you get consent for that next stage? And it's not often going to be clear. This is where it's going to get sort of tricky, but because the consequences can be so serious if you don't have consent for both parties. But let's just put let's say we're not concerned about the legal consequences. Let's just talk about the emotional
Yeah.
consequences. If everyone should know that the consequences of sort of engaging in sex without the other party's consent, not that can have very grave consequences for the person who didn't consent. So I would think, as the consent seeker, you would want to be sure, and the burden seems relatively small.
Well, and it has consequences too it has important consequences for both. Let's leave aside the person who wants to commit a crime by raping somebody or sexually assaulting.
Right.
Right. I mean, if you are seeking consent to take your relationship to the next level, whatever that is, you would hope that you want to do that with the consent of the other person.
Well, but see,
Uh,
this is where I think it's relevant to talk about the opportunism issue.
mm,
If you cared, right? If you cared, you would be sure. If you didn't care, you're just worried about whether or not what you're going to do will lead to charges, right?
yeah.
We should treat those two very differently. Um, but we don't always. I don't think. I don't think we always. I don't think we always treat those two situations differently.
Well, and of course, intimate relationships are further complicated by the fact that it's often just those two people, and it is in the privacy of wherever, the bedroom or their home or what have you, and it's not something that is. Um, it's very difficult to look back and say what happens. That's why the communications become so important, and emphasizing the relational, emotional communication aspects of consent. I think is so important. But well, let's talk about some other ways in which consent can be very challenging, because which are different than the sexual relationship, which has so many of its own complicating factors.
It has so many, yes, and I think that the Me Too movement, there all the different sort of scenarios, right, that we read about, has really brought to light the different sort of degrees of consent or lack of consent, and
Yeah,
how in some cases you have not no consent, you have rape, right, and then you have sort of on that you have that on one end, and then you have the sort of bad date scenarios, the insensitive sort of
yeah.
date scenarios on the other, where you don't have no consent, but you don't have sort of enthusiastic consent, right? You don't have you, you have defective consent, maybe.
Well, and I'm just thinking, I was going to move on, but I'm just thinking of something else that complicates it too, because it isn't just private behavior that we're talking about here. The law does have a role. It wasn't that long ago that there were many states that had laws allowing marital rape, where a husband didn't
Hmm.
need consent to have sex with his wife.
Hmm.
And that's a situation where the law is actually stepping in to dictate when consent is uh, required and when it's not required. So the law does have something to say, even about the most intimate of relationships, when it comes to consent.
Yeah, and that's why I think the law um, that's like, under my framework, that would not be
That would
that would
obviously not.
not be valid consent, and
Right.
that's why I think a framework is so important.
Yeah.
Is to sort of like you know, are we sort of stuck in a particular context, a particular time in history that later we're going to regret? And this is more relevant when we're talking about these novel procedures, that I start the book with, like
Right.
cryonics or cryogenic preservation, right? I sort of lump them all under cryogenics, but cryonics is very different. But there are different experiments going on with freezing of you know different sort of there's a lot of like sort of novel experiments going on that we don't know the short, the long-term effects much, we don't even know short-term effects of consequences of what could happen. So.
Well, medical experiments is a good example, right? Where we know that in history there have been times medical experiments involving syphilis, for example, which you talk about in the book, where people were subjected to experimentation they didn't know, and so obviously they couldn't consent. And we've come a
Right.
long way in the way medical and scientific experimentation is done by really emphasizing the importance of an individual's consent to that type of experiment.
Right. I'm not sure. I don't think you can actually validly consent to something as complicated as a experimental medical treatment. Not in the way I talk about this idea of informed consent is
Yeah.
not really valid consent under my framework. And so at best what you have is defective consent. And with defective consent, we can't default to, well, everyone's responsible for their own actions. It really should be subject to regulation at that point. And nobody gets a waiver, right? Nobody gets to waive their any sort of negligence or any sort of harm. And we really need to have a professional or regulatory body examining the experience to see whether it is one that should move forward. And that is actually what happens currently, at least with official sort of governmental experiments. But there are things going on in private industry that are not subject to the same.
Well, that's so fascinating. I mean, the idea of defective consent. I've actually handled cases over the years involving institutional review boards, which are
Right.
groups of specialists and usually from different backgrounds who look over the shoulders of a researcher who wants to do anything involving human experimentation, say a new cancer drug or a new surgical procedure or something like that. And their job is to make sure that the consent form says a whole lot more than just, do you give permission for me to do this experiment? I've seen them where they're 20, 30, 40 pages long to make sure that the information in that consent leads to true informed consent. But really, if you're someone, say, who has cancer and all traditional medical therapies have failed, and you get wind of some clinical trial, even if you're given a 30 or 40 page consent form that's passed through the hands of lots and lots of pairs of eyes on it, can that actually be true consent? Because,
Right.
are you actually in a position to give consent for something like that?
I would actually say, especially when it's a 20 to 30 page consent form, because you're not likely to read and understand something
Right.
so
Right.
so dense. And the voluntariness condition is lacking. So I would say both the knowledge and the voluntariness condition are lacking. And again, I mentioned 3 conditions required for consent, right? Manifestation of consent, knowledge, and voluntariness. And I think given the seriousness of what you're about to undergo, those conditions have to be very robust. And you don't really have robust voluntariness or knowledge conditions in that situation. And so I don't think you have valid consent. You only have defective consent, which means that we can't, it's that, first of all, there is defective consent in that situation would mean only consent to proceed with the trial, which and the person could get out of it at any time. Now, that's not true for other types of contracts, right? I mean, the whole purpose of a contract is you're bound in the future. It binds you for something, to the future, to do or not do something in the future.
That's a big difference. Yeah,
it's a big difference, and so in those two, so that's, I think, really the issue with a lot of the hard cases that I mentioned in the book. Like whether people should be allowed to enter into a contract to a surrogacy contract or a contract to
Hmm.
sell their kidney or things like that, and very sort of controversial uh, um, topics. Same with experimental procedures. Right now, you most of the time you're allowed to discontinue your involvement, but that may not be true when private industry, when there are more private companies involved in this area that don't require governmental funding, that don't have institutional oversight,
Hmm.
and so that's when we need to really sort of understand what should be permissible and is there in fact consent, because a lot of times people say, well, they consented, they signed the waiver, but that should not be enough when we're talking about a situation where somebody didn't has only defective consent.
Well, talk a little bit about that because I think that's one of the more challenging ideas around the issue of consent. And I appreciate what you said, the difference between contract and consent. If you make an agreement, a contract, and then you just suddenly decide, I don't want to go through with that anymore, there could be consequences. You could have to pay damages to the other party for breaking that contract. But you're saying in consent, there can be conditions where you can withdraw your consent. You can change your mind. There can be things that
Right,
happen that lead you
right.
no longer to want that consent to be given in some situation. But I'm fascinated too with the idea that because I think we think of consent often as something between people. Two people want to do something. Talked about sexual relationship, but also all kinds of things where you're giving permission. And you would think that in a libertarian view of our society, that is, and I think you made this point very early on, as long as I'm not hurting anyone else, why should the government or the state or the law care what I
Mm,
consent to or don't consent to? But the law does care. And there
right,
are all kinds of situations where the law says you may not consent to that, even if you choose to.
right.
From looking at the landscape as you do here in this book, can you see any rationality to that? Is there any way to understand when are there those situations where the law steps in and says you may not consent to that versus other situations where the law leaves it up to each of us to make up our minds about that?
Right. Well, you know, I could sort of guess as to why there are certain laws, why the law permits certain things and not others, and not other activities. But I think I would prefer to look at how to make sense of what the law has done.
Okay.
Why the law is the way, even if even though there are probably different or many different reasons for why we have certain laws. But let's take the issue of you know, let's say selling body organs, right? Like a kidney, let's say. Um, should we allow people to do that? And you think about it, you think, well, the answer is no currently, right? The answer is you cannot. And so why is
But you
that?
can donate
And
your organs. You can be an
but
organ
yeah,
donor.
so that's the thing. So you can donate your organ. So it can't be that we think the procedure itself is too risky, right?
Yeah,
Because we in fact encourage people to donate their organ,
right,
right? So it's not that we think the procedure itself. So it must be that there's something about being paid for it that
right.
makes us uncomfortable. Okay, this idea of commodification, right? But again, what society are we living in, right? We live in a society that really commodifies the human body, whether we like it or not. We allow women we allow people, but but primarily women, undergo cosmetic procedures, which are, just as risky a lot of times
Hmm.
than, having your kidney removed. And there's no societal benefit. Nobody's life is being saved when get cosmetic sort of breast implant surgery as
Right,
opposed to reconstructive. And not only that, you are paying somebody. It's just that you're not getting paid for undergoing that dangerous procedure. You're paying somebody to have it to do it to you. So this idea of payment, well, it can't just be the money being exchanged itself. It has to be something else. Well, what is it? So what about the fear of exploiting those who are poor?
Yeah.
The fear that will have a class of people who will be exploited for their organs, and the idea is very sort of um, grotesque. And some people might say, well, but we already exploit the poor, or they already have dangerous jobs, and that's true. But that doesn't mean that we should continue along that path. So does that mean because of the fear of exploitation, we should um, ban, or we should, make selling your organs illegal, even though lives could be saved, and even though it could be, it could be socially beneficial if we could sort of get rid of, or if we can minimize the risk of exploitation. And so really, we want to hone in on the risk of exploitation. And there's also another fear, which is since we're talking about a contract situation. We're not talking about a situation where somebody consents and it's simultaneous with the act being done, like let's say in a sexual context, right,
Mm.
where you consent and there's not much of a time lag between the act of consent and the activity, right? Whereas when you're agreeing to something in the future, you can change your mind, right? Things might happen which cause you to want to get out of that contract. And when we're talking about something like your bodily integrity, there's something, frightening, sort of about being forced to do something that involves your body that decide you don't want to do later. And so I think if we are going to allow, uh, you know, um, uh, contracting for in these types of situations, that we have to allow contract avoidance. So essentially, they should not be binding contracts on the part of the consenting party, but they should be binding on the part of the other party, meaning that they can't sort of rescind the contract. So it's not that there would be no contract. It's not that the contract should be void, because void contracts, they also have the potential for exploitation. You see it in cases involving prostitution.
Hmm. Well, right. You talk about this in your book. I mean, people can be paid to have sex if it's recorded and put on a video called pornography, but they can't have sex and exchange money for that just because they want to, which,
Right,
you know,
right.
would, I mean, in each case, you could say there's be a strong moral attitude that the law could take to those two kinds of activity, but the law looks upon them very differently.
Right, right. And it's that's interesting because again, money is being exchanged. It's
Yeah.
just under the some people might say, well, expression, but we've kind of uh, I mean, I don't think that's actually a a real. I mean, I think even the Supreme Court is not always thinking that it's that's sort of a dubious argument. I think it really comes down to this idea of the payment for having somebody do something with their body. But hey, we allow you know the extreme fighter. What is the WWE?
Yeah, ultimate, the cage
The
fighting.
ultimate fighting. Yeah, yes,
Yeah,
exactly. And you could even argue football, right? Now
yeah,
that we know how much damage is
right.
caused by and not everybody ends up with the multi-million-dollar paychecks. I mean, a lot of
Yeah.
these guys end up with not a lot of money at the end of their careers.
Well, lots of people
So,
call that exploitation. I mean, people are coming often from not very privileged backgrounds, and they're going into sport like football as a way of getting through college and maybe beyond. And so there's the potential for exploitation in college and professional athletics as well. But we certainly allow that because we don't want that very much. Uh,
right. So I think there has to be a way to get at the issue of exploitation. And I
mm,
propose, or I think that we should maybe think about how we might regulate it so that you don't have people who are desperately poor, selling their body parts for money, but that shouldn't therefore mean that those who are not desperately poor, who might, where you might actually get closer to valid consent, would do it if the price were right. And you see that with, um, you know, uh, with egg. Well, I don't want to say donors, but those who sell their eggs,
Mm-hmm.
right,
Yeah.
where they can get paid a lot of money, and it's there are a lot of complicated issues, but basically. The thing that I don't like about that situation is all the advertising on elite campuses, because again, you have younger women who might have financial issues with student loans and so forth. So it seems predatory in that way, and I think there should be regulation. That advertising should be regulated, but it doesn't mean that the activity itself should be banned. So I do think there are uh, regulatory controls that should be put in place um, if we allow these activities. But I don't think that the arguments that have been put forth so far are reason to ban these activities in a free society.
Well, knowledge, you said, was one of the preconditions of valid consent. Talk a little bit. We touched on this very briefly, and maybe we can wrap up with this area, because again, I think in the newer technology era that we're in, it's not so new anymore. But I mean, I don't know how many times I click accept to the terms of service, or now it seems the latest thing is websites have to disclose cookies, and so as soon as you go to a new website, something pops up and you have to say yes to it to continue. None of us really know what it means to click yes in those situations. We just do it because we want to get to whatever the pages that we were looking for. How do you see consent there, or in some of these other ways in which you agreed to the terms of service, but you probably didn't realize that Facebook was selling your clicking history to advertisers or to
Right.
data mining companies and things like that? I mean, that just seems to
So
pose all kinds of consent problems.
right, and I think it's because it depends on what is being consented to, and I think that's something that, at least in the area of contracts, we tend to say you consented to a contract, you consented to all the terms, which are not sort of unreasonable, which doesn't really help much, right? Because what does that mean anyhow? I think when you I think the way the law should look at that situation is when you click consent, basically you're consenting to not violate or when if you think back to the reason why websites first started to use these terms, it was because you had people stripping content, right? It was so easy to cut and paste and then pretend and copy the content over to a new website. So there were issues of copying content, and that's you know, if you contractually prohibit somebody from doing that, then then you felt a little better. But what happened was the company started to make the terms much more sort of intrusive, right? They started to ask for a lot more because they realized, hey, nobody's reading these terms anyhow. So instead of the terms just saying, you cannot, deep, you cannot copy, or this content is ours. Instead of the terms of service acting as notice, like you put a sign on your lawn that says "keep off the grass," or you can get a drink of water from the fountain, but you know what I mean. Like trespassers will be violated. Instead of being a notice, it became more of a contract, meaning that
Yeah,
it started to impose obligations on you, even though you never read the terms. So
right.
if Facebook says you can't copy, we reserve rights to all of our intellectual property, it doesn't matter if I read that or not. I'm okay with it, right? But I'm not okay if Facebook then, in the unread term, says they want to take something of mine,
Right.
because I want to know what it is that they're taking from me.
Right.
I don't need to know, I don't need to know, because I'm not assuming that I get anything of theirs other than the right to use their website. But I don't want them to take something of mine unless I know about it. So I think that, I think the law should treat those two situations differently. But currently, contract law really doesn't
Well,
in most situations.
I mean, I think that's just going to be an area for all kinds of regulation, new laws, new
I mean, you can
litigation.
agree to,
new-
give up your right to a jury trial, right?
I would never, but yeah, arbitration clauses inserted in contracts all the time. It's a big problem for a lot of people.
Well, you would never, but I don't know. Maybe you already have. I mean, a lot of these online sites have, waivers in their terms of service.
Well, that's a good.
Yeah. So I don't. You probably already have. They're pretty ubiquitous, and you don't even know it.
Well, I would argue that wasn't valid, that they never actually had my consent, and I feel emboldened in that argument now that I've read your book, Nancy. So,
I don't think the Supreme Court would agree with you, unfortunately.
Well, they haven't heard the last on this one. It is really fascinating. A really interesting book. It's out on Cambridge University Press. Consentability, consent and its limits, and we have talked about some ways in which these limits can be very important. So much so that we may not even know that we've been limited, as you just pointed out to me. So check out the book. Nancy, how can people get in touch with you or get a copy of the book if they want to get more information on you or get a copy of the book?
Oh, well, they can get a copy of the book on the Amazon website, but also
Wonderful.
on Cambridge's website, and information about me. You can just look up under my institution, my California Western School of Law.
California Western School of Law in San Diego, California, where I wished I was. Nancy Kim, thank you so much for being on Good Law Bad. It was great to talk with you.
It was great talking to you about this.